So you're getting into an argument with your former co-parent, your ex spouse, your ex boyfriend or girlfriend, whoever. You're getting into an argument, and you don't know the argument's being recorded. My name is Carl Birkhead. I'm an attorney with Wirth Law Office in Tulsa, Oklahoma. I've been practicing family and criminal law for 8 years now, and I want to help you make law easy by talking a little bit about the effect of having conversations recorded in a child custody case. So this is something that a lot of people don't realize. You don't need to give the other side permission to record a phone call or to record an interaction. Let's say you're going to a custody or visitation exchange and you want to video the interaction because you're not, let's say you're not on great terms with your co-parent. Um, it happens all the time. Plenty of people want to record them, and nobody really ever tells the other side that they're doing it. Sometimes they make it obvious. I mean, you can have your phone out and be like, "Yeah, I'm recording. I'm right here." That's fine. Or sometimes people will be a little bit more subtle. Have the phone out, camera on, put it in the breast pockets where it's just sitting there recording everything. You don't ever have to tell the other side what you're doing. They can ask, and if they ask, you can be honest with them, or you can just say, "Sorry, none of your business," because you don't need to have both side consent in these situations. Same with telephone calls. I've had clients time after time either have some app on their phone that records a phone call, or they'll have the phone call going with one phone and they'll like have another phone out video recording it to record the conversation. Because guys, people say some messed up things in the middle of custody cases. People say some scary things in the middle of custody cases, and you need to have a record of that. You need to be able to show, to not just say to the court, "Yeah, no, they said they were gonna choke me with my own hair." You need to be actually able to actually play it for the court. "I'm gonna choke you with your own hair." You need to be able to actually not just say something happened, but be able to prove it also. And the law lets you do that. You don't have to get written permission. You don't have to let the other side know. Just the only thing I will say is do it sparingly, and also be very aware of the fact that it can be done to you. I tell my clients this all of the time, and this applies just as much in person and over the phone as it does in writing. Dance like no one's watching, but by God, text as though or speak as though it's going to be read out loud or played out loud in court. If you have questions about this, give me a call. My name is Carl Birkhead. I'm with Wirth Law Office, and I want to help you make law easy. Thank you.